This Honorable Court of Appeals of Tennessee is now in session.
Good morning, Council. On behalf of Judges Stafford and McBrayer, I'd like to welcome you to the Court of Appeals. We'll be, of course, doing this on Zoom, but we'll do it just like we would in a courtroom. And if there are any technical problems, we'll stop and get them fixed and then proceed. So if there's no announcements, seeing none, Mr. Hivner, would you call the case?
Tennessee Department of Safety and Homeland Security versus David Schell.
And Mr. Monsieur, you're the appellant today, so begin when ready.
Good morning, judges. Herbert Monsieur on behalf of David Schell. This is another in a number of cases in which the policy of the state of Tennessee expressed in TCA 45325A and also in 44033-215 have been to equalize by awarding attorney fees to successful claimants in forfeiture cases. Their attorney fees to put that somewhat on an equal footing. In this case, there was a finding by an administrative judge that there was a fabricated subpoena used to obtain banking information from David Schell. And then once the banking information was obtained by the fabricated subpoena, there was a forfeiture warrant used to seize the property rather than a search warrant or an order of the court pursuant to 5311 451B. So this was just a flagrant violation of the Tennessee forfeiture statutes and the constitutional rights guaranteed under the Fifth Amendment. To which immediately upon the judge ruling, there was an application for attorney fees under both 45325A and under 42 USC section 1988B that has been made applicable to Tennessee's administrative rules. What I would like to address in my argument is the Chancellor's ruling that Schell or I waived on behalf of Schell the claims under section 1988B because those claims were not specified in a motion for reconsideration. The motion for reconsideration was filed because at the same time that the judge denied attorney fees on March the 10th of 2017, Chancellor Perkins decided the Berlanga case and ruled that 45325A was applicable to the department, and that if 45325A fees were granted, that the constitutional issues for section 1988B fees would not be addressed. That ruling of Chancellor Perkins was binding upon the administrative judge pursuant to Administrative Rule 1340-0202-18(7). So the only thing that could have been raised back under Berlanga before the administrative judge was the question of the application of Berlanga, and that was promptly brought to his attention. Now, the Chancellor ruled that Schell waived by not bringing in the motion for reconsideration the claim under section 1988B. However, Tennessee in administrative procedures, Tennessee Code Annotated 45317 specifically provides that a motion for reconsideration is not required for appellate review. Now, the chancellor construed this at page 223 and held, but whereas here Mr. Shell did petition to alter or amend the ALJ's final order, which required to set forth, quote, specific grounds upon which relief was requested. He did not include in his position to alter or amend any request for an award of fees under Section 1988. And therefore, she concluded that all grounds had to be included in a motion for reconsideration or they were waived. However, there is no law to support that. And in essence, what that does is creates a motion to reconsider under 45317 into the equivalent of a motion for a new trial in the criminal procedure that requires all issues to be addressed. Well, in this case, the only issue to be addressed was Berlanga. And courts have been specific that attorneys are not to relitigate issues where there is no new basis or basis for a reconsideration. So therefore, the question of Berlanga did not waive Section 1988B under the administrative rule of 45317. I would only note that the chancellor equated the motion for reconsideration to alter or amend the findings, which of course is a civil rule and is not contained in the administrative rules that specifically provide that an issue is not waived if not raised in a motion for reconsideration. Let me move very quickly to the chancellor's ruling that 45325A did not apply to the Department of Safety because Mr. Shell was not issued a citation within the meaning of 45325A. And the chancellor relied on this court's unpublished opinion authored by Judge McBriar that held by obiter dictum because that appeal was the case was reversed on other grounds. But here's what the court in Groves held, quote, here, Mr. Groves was not a party issued a citation for the violation of a rule, regulation, or statute. The only document sent to Mr. Groves was a notice that a forfeiture warrant had been issued for the vehicle, primarily so that he could take steps to protect his interest as co-owner. Now, in my briefs, or Mr. Shell's briefs, we've set out the provisions of the notice of seizure and also the letter that was issued by the Department of Safety directly to Mr. Shell. It first noted, and I did not include that in my citation, that he was identified as having an interest, ownership interest in the vehicle. It then went on to say the vehicle or other property described on the notice of seizure form was seized in accordance with TCA section 4033-201 et sec upon reasonable belief that said vehicle or other property was used or intended for use to transport or in some manner to facilitate the sale or receipt of controlled substances, or that said property was otherwise used or intended for use in violation of TCA section 53-11-451, which of course is the Tennessee drug statute. Now, it is our contention, and we believe it was not addressed in Groves, that provision of the letter that was issued to Mr. Shell did cite the violation of statutes. Clearly it did. And no court, to my knowledge, including the Chancery Court in this case, has addressed that provision of the letter that was issued by the Department of Safety. I see that my initial 10 minutes is about to expire.
Thank you, Mr. Monsieur. General Mitchell.
Good morning, and may it please the court. My name is Rob Mitchell, and I'm here on behalf of the Tennessee Department of Safety and Homeland Security. This court should affirm the judgment of the Davidson County Chancery Court, which reversed the ALJ's award of attorney's fees under section 45325. Contrary to respondents' contentions, the ALJ's order was a final decision subject to judicial review under the UAPA, and also the ALJ erred in awarding fees under section 325 because no citation was issued by the Department of Safety and Homeland Security. I'd like to begin by addressing the attorney's fees issue first. Section 325 is clear that when a state agency issues a citation to a person for the violation of a rule, a regulation, or a statute, then that person may be entitled to attorney's fees if other requirements are met. And here, the record in this case is clear that no citation was issued by any state agency, including the Department of Safety and Homeland Security. Instead, what the record shows in this case is that a detective with the Marion County Sheriff's Department investigated respondent for drug trafficking, including using a confidential informant, and ultimately procured a forfeiture warrant for one of respondent's bank accounts. Yet, despite that seizure by the Marion County detective, respondent insists that it is the Department of Safety and Homeland Security's letter notifying respondent that a forfeiture warrant was issued that actually amounts to a citation, or as respondent argues, the functional equivalent of a citation. This insistence by respondent, though, is mistaken for two reasons. First, as Mr. Monsieur acknowledged, this court in Groves made clear that such a notification letter by the department is not a citation by a state agency under section 325. And second, petitioner's insistence that the department issued a citation is mistaken because it fundamentally misapprehends the role of the Department of Safety in forfeiture proceedings. Forfeiture warrants are sought by seizing agencies, such as local police departments, or as here, a county sheriff's office. Then after the department learns that forfeiture warrants have been issued, the department notifies people with potential ownership interests, such as the parties who were in possession of the property when it was seized, owners, banks, or other lien holders, of the issuance of the forfeiture warrant. So to insist, as respondent does, that this notification is a citation that should fall into one of section 325A's subsections defies the plain meaning of a citation for a violation of a rule, regulation, or statute. And what's more, as the Chancery Court noted, to the extent that section 325 authorizes an award of fees against the state, it ought to be strictly construed because this would be an abrogation of the state's sovereign immunity. And so accordingly, the Chancery Court correctly reversed the ALJ's improper award of attorney's fees under section 325 because the department did not issue any citation. Likewise, respondent is not entitled to attorney's fees under section 1988 either. Not only did respondent waive this claim by abandoning it before the administrative law judge, but also the ALJ failed to make any findings that could warrant an award of fees under section 1988 against the Department of Safety and Homeland Security. First, the Chancery Court found that respondent waived review of his section 1988 claim because at best it was insufficiently stated before the administrative law judge. And in any event, if it was stated, it was subsequently abandoned in respondent's pursuit of attorney's fees under the 325 argument. Indeed, as the Chancery Court noted, after initially mentioning Section 1988 fees, respondent made 4 additional filings with the administrative law judge about his request for fees under Section 325, and none of those 4 filings made any mention of Section 1988 or the 2 cases that respondent relies on, Bloomingdale's by mail and Wimbley. So this omission in these 4 subsequent filings amounts to a waiver. And second, even though the ALJ found that the Marion County Sheriff's Detective violated the investigative subpoena statute in the Tennessee Code, the ALJ did not find that the Marion County Detective violated a federal law or a constitutional provision. In the same vein, the ALJ's finding that the department did not show by a preponderance of the evidence that the seized bank proceeds were linked to drug trafficking was a weight of the evidence finding, not a finding of a violation of federal law or constitutional provision as is required under Section 1988.
But your point is, even if there's not waiver or an abandonment of the issue, 1988 still wouldn't work here under the ALJ's findings.
Correct. That is my point. So there's 2 reasons that 1988 is not proper here.
So let's talk about waiver for a moment. I'm assuming that essentially you are saying, or that the ALJ or the trial court rather, excuse me, is saying just because this the 1988 claim was not mentioned in the subsequent filings, that the court was assuming that it was waived. Is that correct?
Yes. Mostly. The Davidson County Chancery Court said that if it was stated, if it was preserved at all before the ALJ, it was subsequently abandoned and waived. But I think the Davidson County Chancery Court's language was it was insufficiently stated at best.
So what needs to be stated then?
I think, as I recall, before the ALJ, it was a summary mention of 1988. It wasn't a developed argument. And that was one of the things the Chancery Court noted was, one, even if there was some sort of mention of 1988, which there was a cursory mention of 1988. 1, it was abandoned. 2, it was omitted in 4 subsequent findings. 3, when it was mentioned, it wasn't developed. 4, there were no facts or findings by the administrative law judge about a violation of a federal law or a constitutional provision. And then in any event, that's before even getting to the fact that 1988 is discretionary. And if an award of fees under 1988 was made, wouldn't it properly be against the Marion County Sheriff's Office who seized the property and obtained the warrants? And of course, they weren't a party here. So that whole analysis was kind of pretermitted by the Davidson County Chancery Court's finding that the 1988 argument was abandoned at best.
Okay.
And beside the attorney's fees arguments, respondent also argues that the ALJ's order awarding fees was not a final order, and therefore the Davidson County Chancery Court lacked jurisdiction to review that order. And the crux of this contention by respondent is that since respondent sought fees under both Section 325 and Section 1988 under respondent's view, the ALJ was therefore required to analyze both those arguments in advance of one goal, namely the award of fees, even though the ALJ ultimately awarded fees under Section 325. But contrary to respondents' contentions, the case law is clear that when there are multiple arguments, a favorable decision based on one argument can pretermit addressing the others. So to here, because respondent advanced multiple arguments for the same end, namely an award of attorney's fees, and because the ALJ awarded fees based on one of those arguments, Section 325, the other argument for fees under Section 1988, was pretermitted. And the fact
what does that mean? We use the language all the time, but what's the legal significance of pretermitting something in this context?
Well, respondent advanced these 2 arguments for fees, and under case law, courts don't have to address constitutional violations when there's another argument or basis to provide relief. And so that's what happened here, was the administrative law judge found relief based on a statutory provision, section 325. And so it didn't have to address this other argument in advance of the same end. Even if that other argument, as was mentioned a couple minutes ago, was preserved and was stated, which again would be contrary to the Davidson County Chancery Court's finding that it was insufficiently stated at best and undeveloped and abandoned.
Well, but what I'm asking, perhaps, and I need to ask it more specifically, is if the trial court, at least not specifically, but just generally determined that this claim under 1988 was pretermitted, if the court finds that the reason the claim had been pretermitted no longer exists, what's the proper role of the court at that juncture?
I'm sorry, if you mean this court, Your Honor.
No, I mean the trial court itself who reviewed the ALJ's findings.
If I understand your question, Your Honor,
let me help you. You're saying that basically the trial court pretermitted 1988, even if it was a valid claim.
I'm saying the ALJ pretermitted it. I'm sorry.
Okay, well, the ALJ pretermitted it, and then the trial court found that the claim had been pretermitted. Not specifically, but basically that's what happened here. So if the trial court found that the ALJ had pretermitted that claim, what was the trial court required to do with a pretermitted claim that was no longer pretermitted?
If the claim was no longer pretermitted and it had been, then I suppose under 45322 standard of review, the trial court would be required to remand the case to the ALJ for a finding on that claim, assuming it was no longer pretermitted and the trial court found that and there wasn't an independent basis for relief.
Well, essentially, isn't that what the ALJ did? The ALJ found this claim to be pretermitted?
The ALJ did not address that claim, you're right, because the ALJ awarded fees under section 325 against the department. Based on a case that Mr. Monsieur cites that was in the Davidson County Chancery Court. But the ALJ's award of fees against the department didn't include the findings of fact and conclusions of law that it's required to under the standard of review. And so it was on that basis that the trial court reversed that finding.
Correct. I'm just trying to figure out assuming as you have suggested, the ALJ found the claim to be pretermitted, it goes to the trial court reviews it and determines that the basis that pretermitted the claim by the ALJ no longer exist. What is the trial court required to do at that point in time?
And if I recall the trial court's decision, the pretermitted portion of its analysis was an alternative as to the 1988. I think the trial court started with the conclusion that the 1988 argument was insufficiently stated at best and was waived and undeveloped and abandoned in those 4 subsequent filings. And then even if after all of those results, somehow the 1988 claim was still standing, then in any event, it was pretermitted because of the conclusion on the other result. And so then to answer your Honor's question, I think if the trial court had started with the pretermitted conclusion, it would have been required to remand the case. But for the reasons stated, it didn't get there. That was an alternative holding.
Okay, thank you.
And so, contrary to respondents' argument, the Chancery Court did have subject matter jurisdiction over this case, and respondent himself invoked the Chancery Court's jurisdiction by filing what he designated as an answer and a counter petition for judicial review, a cross notice of review. in which respondents sought judicial review of a final order entered by an administrative judge reducing an award of attorney's fees and costs. And that's respondent's language. And so as the Chancery Court pointed out, respondent cannot invoke the court's jurisdiction for review of an administrative decision, and then at some point, years into the litigation, change course and argue that actually there was no final decision by the administrative law judge. And so, in addition, as discussed, the Chancery Court found that respondent waived review of his 1988 fees claims. And for those reasons, Your Honor, the ALJ's order was a final one, subject to both judicial review and reversal by the Chancery Court. And this court should affirm the Chancery Court's judgment.
Thank you, General. Mr. Monsieur?
Yes, with regard to the department making a determination in this case, as the administrative judge found, and TCA 4033-204G requires that the department independently do anew a determination as to whether there are factual or legal bases for the forfeiture, and if there are not, to return the property. So consequently, the department then made the determination independent of the administrative judge, of the judge issuing the forfeiture warrant of these matters, and issued the letter that we have spoken of and adopted the notice of seizure. Therefore, as the administrative judge found and as required, the department then became the seizing agency that as a state agency that sought the forfeiture of the property. With regard to the questions by Judge Stafford, with regard to what changed between the administrative judge choosing not to address not Section 1988B, Shell immediately upon the state filing its petition for judicial review, which removed the jurisdiction from the administrative judge who no longer had subject matter jurisdiction, Shell filed in the Chancery Court 2 motions. One motion was under Rule 60.02 that no longer did the application of the administrative judge's awarding the fees under 45325A equitably apply because of the intervening order or the intervening judgment in Groves. And number 2, the material change of law under 60.02, 4 and 5 justified the Chancery Court granting relief from the order, and pursuant to 45322 H1 and 3, I agree with my colleague, Mr. Mitchell, that the Chancery Court, upon the underlying basis for awarding attorney fees being no longer available, was to remand the pre-permitted or the other claim that was in the administrative judge back to the administrative judge to consider. Mr. Mitchell argues that because the judge awarded fees under 45325A, that the Section 1988 did not need to be considered. And that's what Chancellor Perkins held in Berlanga. But once that initial ruling was taken away, then the remedy available was the Section 1988B, and the Chancellor should have remanded that pursuant to the motions properly filed by Mr. Shell back to the administrative judge to consider. let me look at my notes right quick. With regard to this issue of whether constitutional violations were established, while it is true that the administrative judge did not make his findings in the context of constitutional provisions, Berlanga and Wembley make it perfectly clear that if the evidence establishes constitutional violations, although they are not pleaded and although they are not relied on, then Section 1988B applies. And certainly the findings of fact of forgery, fabrication of.
So you're saying Berlanga makes clear that you apply or award 1988 attorney's fees, even if there's no finding of constitutional or federal statutory violations?
No, did I say Berlanga? I probably
Yes.
Bloomingdale.
Okay.
Thank you, sir.
Yeah.
I was referring Bloomingdale's and Wembley made
Okay.
that clear, made that perfectly clear. So the argument that the facts in this case do not establish a violation of the Fifth Amendment are just not correct. The last thing I'd like to say is that the quotation from Springer is very clear that the due process clause of the Fifth Amendment is invoked when there is a exercise of forfeiture, and that where there is a violation of the law of the land, as there was in this case, that constitutes a violation of the due process clause of the United States Constitution, Fifth Amendment. I don't know how the Supreme Court could have been clear in what it said, and I believe.
Thank you.
Yes, sir.
Thank you, Mr. Monsieur. Your time is up. You've given us a lot to think about. Mr. Hivner, would you please recess court?
This honorable court is now in recess until 1 p.m.